Our first item of business this morning is to consider a government motion to opt in, pursuant to Protocol 21, to Regulation EU 2018-1727 of the European Parliament and of the Council of the 14th of November 2018 on the European Union Agency for Criminal Justice Cooperation, otherwise known as Eurojust, and replacing and repealing Council Decision 2002-187-JHA. I welcome the Minister for Justice and Equality, Charles Flanagan, and his officials. Before we begin, I am obliged to remind members to be aware that under the salient rulings of the Chair, members should not comment on or criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. I now invite the Minister to make his opening statement. Thank you, Minister Flanagan.
Thank you, Caoimhghín. Thanks to the committee members for taking the time to consider this matter this morning. I'm joined by officials on my right, Brendan Eve, on my left, James Maloney, whose names I see in lights. And the issue under discussion this morning is whether Ireland should opt into the new Eurojust regulation, thereby maintain its membership of Eurojust. Indeed, it's my view, Caoimhghín, and members, that Ireland should, and that the Oireachtas should approve the necessary resolutions to enable this to take place. Furthermore, members of the committee need to be aware that a consequence of not opting into the regulation will be that Ireland will have to withdraw from membership of Eurojust. It may be helpful, Caoimhghín, if I provide some brief background on the matter. Eurojust is the EU's Agency for Criminal Justice Cooperation. Its role is to provide assistance to members in criminal investigations involving 2 or more EU member states. The structure of Eurojust is centred around a college of prosecutors, which is comprised of prosecutors from each of the member states. These prosecutors are based in The Hague in the Netherlands, and the college meets on a regular basis to discuss cases which fall within the remit of the agency. In Ireland's case, a prosecutor from the Office of the DPP here in Dublin provides representation on a full-time basis on behalf of the Irish State. The college's primary role is in assisting in clearing difficulties and logjams that arise in multinational criminal investigations and dealing with mutual legal assistance requests for evidence and surrenders under the European Arrest Warrant. The location of the EU prosecutors under one roof at Eurojust facilitates the rapid exchange of information and addressing of issues of relevance. The agency has contributed greatly in this regard, and membership is highly valued amongst EU states. The UK, for example, despite its position on Brexit, has opted into the new regulation. As I've said, it's not about Ireland joining Eurojust, but in fact remaining a member, because Ireland is already a member of Eurojust and has been since the inception of the agency 17 years ago. In order to clarify the position, Eurojust currently operates under the provisions of Council Decision of 28th of February 2002, setting up Eurojust with a view to reinforcing the fight against serious crime, 02187/JHA, the original Eurojust regulation. The new regulation under discussion today retains many of the provisions and structures of its predecessor, but also provides a framework for the modernisation of the agency. Because the new regulation comes within Protocol number 21 on the position of the UK and Ireland in respect of the area of freedom, security and justice annexed to the TEU and to the TFEU, there is a necessity for our Oireachtas to agree that Ireland should accept the measure. The main features of the new regulation are that in Chapter 2, Articles 6 to 18, it revises Eurojust governance structure by setting up an executive board to deal with administrative matters. Therefore, Eurojust's college, which, as I've said, consists of prosecutors from all EU member states, can focus more strongly on operational issues. The ever-increasing numbers of Eurojust cases require a more efficient way of case handling. The new regulation will make Eurojust fit for this purpose. The new regulation doesn't replace the successful core concept of the College supporting the national authorities in their investigations and discovering links between cases. Rather, in Articles 2 to 5, it confirms the current proactive role of Eurojust in its operational, strategic and tactical work. In other words, the operational practices in place for the past 17 years in which Ireland has played a part will not change. This work involves coordinating approaches in the most serious forms of criminality, including murder, people trafficking, child sexual exploitation, drugs trafficking and terrorism. Chapter 3, Articles 19 to 25 deal with operational matters and provide details of the operational structure of Eurojust, including a 24/7 on-call service for Member States. Of major significance, in Chapter 4, Articles 26 to 46, the new regulation brings Eurojust in line with data protection rules that the European Union adopted last year. The GDPR Associated Law Enforcement Directive takes into account Eurojust's specific mandate to process data in the interest of fighting cross-border crime. Eurojust operations will also be subject to the scrutiny of the European Data Protection Supervisor, as set out in Article 40. In Chapter 5, the regulation addresses Eurojust cooperation agreements with third states, international organisations, both of which are subject to the aforementioned data protection provisions. Eurojust operations and budget is also subject to the scrutiny of the European Commission, the European Parliament and the Council of the European Union Member States. There is no expectation of a budgetary contribution required from Ireland in the context of the running of the agency. Ireland's national member is, of course, remunerated by the state in the same manner as any official of the state who is assigned to duties overseas. This small cost, when measured against the service made available to Ireland through membership, represents a small price to pay. As Minister for Justice, I am also the central authority for the provision of international mutual legal assistance to and from other states. In the past 5 years, the volume of cases being dealt with has doubled, set to increase by in excess of 50% per annum going forward. These stats alone illustrate the increasingly transnational nature of serious crime. It's also relevant, Caoimhghín, to point out that in the 4 years up to the end of 2018, the Irish desk at Eurojust has handled in excess of 800 cases with an Irish dimension. These have included cases involving serious international fraud, sexual offences and trafficking of vulnerable young women into the state for the purposes of engaging them in prostitution. Transnational problems require transnational approaches. As Minister, I must ensure a comprehensive response to the issue, and this state's continued membership of Eurojust plays an essential part in this response. Taking into account that the core function of Eurojust is to assist in criminal investigations, the fact that it has a proven track record in this area over the past 17 years and is subject to the most advanced data privacy protection regime in the world, there are few who would argue that it would not be desirable for Ireland to remain a member. Furthermore, it seems to me that there is an issue of principle here. This cannot be just what Ireland receives. It's about playing an active part in the European Union and the welfare of its citizens. Notwithstanding the negative effect on criminal investigations in this state, our EU colleagues would see an Irish withdrawal from Eurojust as a negative development. I needn't remind committee members that Ireland has relied heavily in recent times on the solidarity and support of other member states. Membership of the Union brings with it a responsibility to act collectively to help solve the problems and threats that the Union faces. Serious crime is certainly one of those threats. It would be unfortunate if Ireland were to be perceived as, on the one hand, seeking the support of other member states, but on the other, not willing to play a full part in the advancement and betterment of the European project. As I said recently in a response to a parliamentary question from Deputy Wallace of this committee on this matter, there are few who would argue that Ireland's membership of the European Union has not been of enormous benefit to Ireland's citizens, both economically and in terms of the progressive social development of our state. The freedoms enjoyed by EU citizens and the real and genuine protections afforded to their fundamental rights are the envy of many throughout the world. Indeed, this commitment to protecting fundamental rights is not some empty aspiration, but a reality backed up by formal structures such as the European Court of Justice and the European Parliament. The freedom of movement of EU citizens is one very clear benefit of membership of this Union. Unfortunately, there are always those who will seek to exploit privileges such as freedom of movement for their own nefarious ends. And much recent EU law in the criminal justice sphere has been aimed at trying to counter the abuse of these freedoms while also protecting them. The European arrest warrant is one such example. Another example is that of Eurojust. As Minister for Justice and Equality, I don't believe it would be desirable to lose membership of Eurojust. International serious crime is an issue which affects all member states and their citizens, and of course, as we all know, it has countless victims. Coordination of measures to disrupt this activity, ongoing communication between states in relation to such measures is not only desirable but essential. Eurojust provides an efficient and effective way of ensuring this cooperation occurs, and I can think of no rational, coherent reason as to why Ireland should not be involved. I therefore, Caoimhghín members, commend these motions to the committee. Thank you.
Thank you, Minister. I open up the opportunity to members who wish to indicate. Deputy O'Callaghan.
Yeah, just be very brief, Chairman. First of all, thank the Minister and his officials for coming in. I support Ireland's membership of Eurojust. I think it's been very beneficial to the country for prosecutors from this country to meet with others from Europe. I think it will be even more important in the aftermath of Brexit, or indeed just with the threat of Brexit. And I think we should continue our membership, and for that reason I support opting into this provision. Thanks.
Okay, thank you, Deputy O'Callaghan. Are there any other members wishing to contribute? We're okay. Right, I'm not going to labour the situation in the absence of any other member wishing to contribute. I'm going to read the following. In accordance with Standing Order 90 and Standing Order 89.2, messages will be sent to the Clerk of the Dáil and the Cathaoirleach of the Seanad that the Joint Committee on Justice and Equality has completed its consideration of a motion to opt in pursuant to Protocol 21 to Regulation EU 2018-1727 of the European Parliament and of the Council of the 14th of November 2018 on the European Union Agency for Criminal Justice Cooperation, Eurojust, and replacing and repealing Council Decision 2002-187-JHA. We shall therefore suspend for 1 minute before moving on to our next item of business, and I thank the ministers and officials for attending. Caoimhghín. If he is that what you're saying?
Yeah.
Yeah, we have the parental leave, and what time is that at?
That will be in our normal mornings now.
9 a.m. That's a Wednesday, isn't it?
To get this room again at 4:45. So I can check his availability for that.
Good man, go for it.
Now, another possibility is on June 26th, the date we originally invited him. We could get around at 6:15. Now it might be a little bit late, I don't know.
Not at all, not on a Wednesday. We're here till 10 o'clock at night. Wednesday, it's not an issue.
Okay.
Session, and the purpose of this part of today's meeting is to conclude. It's not actually, it's to continue, let me get it right, a series of engagements examining the direct provision system and the international protection application process. This is the third of our series of 4 hearings, and this will also include a visit to direct provision centres later this week, just to share that with our guests this morning. We are joined from the Children's Rights Alliance by Tanya Ward, Chief Executive, and Julia Hearn, Access to Justice Manager. From NASC, the Migrant and Refugee Centre, we are joined by Fiona Finn, Chief Executive, and Fiona Hurley, Communications and Policy Officer. And from University College Dublin, we are joined by Dr. Liam Thornton. You're all very welcome before the Justice and Equality Committee this morning on this very important issue. I will shortly invite each of you, while you're designated spokespeople initially in terms of opening statements, and I propose to do it in the order in which I've just introduced you and welcomed you. But before I do that, I must draw the attention of our witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person or persons or entity by name, or in such a way as to make him, her or it identifiable. And again, members of the committee should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. Again, may I ask that everyone have their mobile phones on silent, please, because it impacts on the recording equipment. So without any further ado, I'd like to invite Tanya to make her opening statement on behalf of the Children's Rights Alliance.
Thank you very much, and thank you to the committee for the invitation to speak here today. The Children's Rights Alliance is an umbrella group. We bring together over 100 member organisations with the goal of making Ireland one of the best places in the world to be a child. We were members of the working group and were appointed by the Minister for Justice at that point, Francis Fitzgerald, and it was our job on the working group to represent the interests of children and young people, and a lot of our work was informed by our member organisations who put a huge amount of time and investment into the working group process. And I have to say, my experience of being on the working group was it was difficult, as you could imagine, but the human rights issues that I saw were probably some of the worst I'd ever witnessed in the country. There was huge levels of institutionalisation, not only of the people living in the system, but also the people working in the system and managing the system. Huge amounts of overcrowding, hunger, welfare issues, mental health, issues of basic human dignity. So one of the only positives I saw at that time was that children were getting to go to school, and that made a big difference to children and families. But by and large, they were living in abject poverty and isolation and exclusion. And I suppose looking at the work of the working group and looking at the changes that have been made, because there have been some significant changes since the working group process. The Department of Children and Youth Affairs went on to carry out a consultation with children and young people in the direct provision system. And some of what they found very disturbing, but there has been some action on by the Department of Justice. The direct provision payment for children, which was £9.60 for a 15-year period, has increased to the McMahon recommendation of £29.80. The first increase was by Joan Burton as Minister for Social Protection, then by Leo Varadkar when he was Minister of that department, and then most recently by Regina Doherty. The Ombudsman for Children can now take complaints from children in direct provision. And I suppose what's significant about that, because what we found about the direct provision system at that time, there was no public oversight of it. This was a system that was allowed to continue with poor procurement procedures, no public oversight by bodies like HICWA, no proper complaints mechanisms, so where situations of ill treatment and maladministration were allowed to continue. So it's really important that you do have these individual complaints mechanisms. There's been some improvement in terms of cooking facilities. A huge amount of work has gone into the development of national standards for refugee accommodation, and that's really key, because our way to end direct provision, or to change it as we know it, is to accommodate families in own door accommodation in small clusters with care and social care people working on site, because some of these families are very vulnerable, but at the same time they were being institutionalised in these institutions by people with no experience to work in direct provision or working with refugees at all. And the national standards, in our view, could provide for that. There's one key recommendation, is that families should be in own door accommodation. The other things I've seen in terms of improvements, there was a reduction of overcrowding over the period. There was certainly an effort to try and address that, because it was inhumane. Been in one centre I visited on the working group, there were 4 women living in one hotel room side by side, their beds side by side, and they spoke different languages, and they had been living like that for 4 years. So that was the kind of overcrowding we were seeing at that time. And the last point, I suppose, in terms of improvements, is the fact that people who were 5 years or more in the system did have their claims expedited, and several thousand refugees got out of direct provision as a result. In terms of where we go next, I have to say some of these improvements are being overshadowed by the fact that we have over 500 plus people seeking asylum, including many children, now in these emergency accommodation facilities that we know are very close to situations where children are living in homeless accommodation. They haven't been assessed, their health needs haven't been assessed. We're very concerned that some of the children don't have access to schools, nor do the parents have support to find a school. And we're also concerned about the child protection issues in relation to these centres, because if you run a direct provision facility, you have to comply with children first. You have to have those procedures in place. You have to have a designated liaison person, and we just don't know what's happening with these emergency centres, and we're very concerned about that as well. If we're very serious about changing the system, we have to implement the national standards that are now that are yet to be published, but they need to be implemented. But we also have to have unannounced public inspections. It is not good enough to have some private operator that you employ to look at whether the provider complies with the contract. We have to have a body like HICWA. That's the only way we'll get the assurance that we'll never go back to the direct provision of the past. And I suppose the last point I want to bring to the committee's attention, I suppose, is generally in the area of welfare and child protection. We know at the moment that within Reception and Integration Agency, the social worker post, so the social worker who has overall responsibility for overseeing the system, has been vacant since November, and that's a long period of time. And at the same time, we have these emergency facilities opening up as well. So who is actually the watchdog? Who is keeping eye on what's happening for these children throughout the system, but also in these emergency facilities? And my final point, I suppose, is just to bring attention to unaccompanied minors in the system as well. We met many of them when I was on the working group. We've met many of them since, and many of our member organisations have communicating with us. But the main issue coming from them is that often their asylum application is not being lodged when they arrive in the country by the social worker, and they are discovering this at the age of 18, and often what happens at the age of 18, they are sent into the direct provision system. So in summary, since the working group report, there have been significant changes, but I have to say there are also significant challenges that have to be dealt with, and I absolutely think they are not insurmountable, and they can be addressed through good decision making and by using the evidence. Thank you.
Thank you very much. I better not say, well, now go to Fiona, because there's 2 of them. No, I presume, Fiona Finn, you're going to take lead. Are you the opening statement? Please, Fiona.
Okay, thank you.
On behalf of MASC.
Yeah. Good morning, everyone. I'd like to thank the committee for inviting us here today to address these critical issues. NASC is an NGO and a charity that works with people seeking protection. We work with refugees, migrants and their families to realise and fulfil their rights. We run a free legal information advice service and we support 1,300 people annually. We also deliver outreach to the 5 centres in the Cork City and County. NASC are a member of the working group on direct provision and the protection process, and we were also a member of the advisory group established to set standards for direct provision. We welcome the fact that the committee are looking at both the asylum reception system and direct provision, as well as the direct provision, because the two are inextricably linked and they cannot be viewed or repaired in isolation. Given the breadth of the committee's remit, I'll focus on a few key issues and recommendations that have emerged based on our 19 years' experience in working with protection applicants and NGOs on these issues. The journalist Masha Geeson had a piece on direct provision in the New Yorker magazine last week, and it was titled "Ireland's Strange, Cruel System for Asylum Seekers." I think, in fact, most Irish people wouldn't find it strange that the state's chosen model for reception of people seeking protection is one of institutionalisation. Historically, we have always institutionalised, excluded and contracted out the care of vulnerable adults and children. And it's very clear from listening to the personal testimonies from the members of Massey at the last hearing that our for-profit institutional model of reception fails to respect the human dignity of asylum seekers in Ireland. Our current reception model takes an out-of-sight, out-of-mind attitude, leading to the systematic and structural othering of people seeking protection. It must be acknowledged and welcomed that there now exists a real openness within the Department of Justice and among some political quarters to radically change and overhaul our protection system. I think this is building upon a number of very important positive changes that have been made in recent years, including opting into the Receptions Conditions Directive, which puts our reception system on a statutory footing for the first time, and it provides additional remedies and protections for applicants, including a vulnerability assessment and the granting of open access to the labour market for protection applicants who have not had a first instance decision in their application within 9 months. We've also seen the development of the national standards, which, when implemented, will apply to all accommodation centres. We've had an increase in the weekly allowance of €38.80 for adults and €29.80 for children. But notwithstanding these improvements, serious structural and systemic issues still remain and will continue to prevail as long as we retain our current institutionalised for-profit model of asylum reception. Many of the underlying issues caused by for-profit institutionalisation and lack of oversight and accountability remain. We recognise that dismantling a system that has been embedded for almost 2 decades is challenging, and it will not and cannot happen overnight. However, there are a number of critical steps that urgently need to be taken to start to move us towards a protection and reception system that addresses and respects the fundamental rights of protection applicants. Firstly, delays in the determination process have been a constant feature of our protection process. The current median wait times for the processing of applications now stands at 15 months. This is a long way off from the promised 6-month wait time originally cited when the International Protection Act was enacted. In our experience, the wait times with no upper limit is one of the primary issues raised to us by applicants. Additional staff and resources must be allocated to the International Protection Office to ensure that they can deal with all applications on hand at any one time in a timely and efficient manner. Secondly, Chapter 3 of the McMahon report, which deals with the determination process, provides us with a number of very clear, unanimously agreed but yet to be implemented recommendations aimed at improving the process. These include consideration of introducing a rolling system whereby all persons in the protection system for 5 years or more should be given a protection status or permission to remain if they have cooperated with the process and in line with statutory obligations. An annual review of the system with a view to making recommendations to guard against any future backlogs, and introducing mechanisms to regularly review the quality of the decision making. The Civil Legal Aid Board must also be properly resourced to ensure that applicants have access to effective early legal advice. As was demonstrated by McMahon, a reduction in the processing times and improvements in the decision-making process not only benefits the applicants, but in the long run will result in cost savings to the state. These recommendations were made in conjunction with multiple government departments and were unanimously agreed as significant steps to improve the protection process. They must now be implemented in line with McMahon. In addition to implementing the above recommendations, with regard to the short or medium-term improvements to the material conditions for those living in the system, We now call upon the Government to introduce with immediate effect the vulnerability assessment. This is provided for under Article 21 of the Receptions Conditions Directive, and it obligates Member States to take into account the special reception needs of vulnerable applicants. This is a legal requirement, it is not an optional extra. We would also recommend that the national standards are published and implemented, and that an appropriate independent inspectorate body such as HICWA be appointed as an inspectorate to implement the standards. And in line with McMahon, all families should have their own private living space, and cooking facilities must be installed in all centres. I'd now like to briefly turn to the longer-term challenges that need to be made to create a protection system that is reflective of the key tenets of a modern democracy, a system that respects privacy and human dignity. We fully agree with the Irish Refugee Council's recommendation that responsibility for the provision of reception for protection applicants should not be under the aegis of the Department of Justice, as their expertise does not lie in housing and the provision of social care. A housing policy approach is needed. A cross-governmental approach is required, as the issues that need to be addressed are multifaceted and they cut across a number of government departments. Similar approaches are commonly employed in other jurisdictions such as Canada and Australia when they're seeking to address critical social issues. We need to move from our current reliance on private accommodation providers and create the conditions upon which approved housing bodies with expertise in the provision of housing and social care can provide suitable self-contained accommodation for protection applicants. This will require changes to the tendering process and to social housing funding streams to allow for a variety of accommodation types in the community. We need to move away from institutional settings. The state should also build fit-for-purpose, self-contained housing units, and the accommodation provided must be a blend of independent and supportive living to ensure that they cater for the needs of all applicants. Requisite support should also be provided. Finally, it has been 4 years now since the publication of McMahon, and like most reports, compromises were made on both sides to achieve a consensus. While the report is by no means perfect, but it does contain clear recommendations which, if implemented, would greatly improve the efficiency and effectiveness of our determination procedure and would provide a really good starting point for a more fundamental realignment of our protection and reception system. The lack of implementation of some key recommendations is possibly why we are here some 4 years later today. All the while, the real human casualties of the government's inaction are the men, women and children living in limbo, waiting in a system that, as Geeson cogently noted, boils the process of seeking asylum down to its essence: waiting. Thank you, and I would be very happy to answer any questions you may have on our statement. And I would just like to mention to the committee that within the bundle of submissions that we have provided, there is also a submission there from Amok LGBT, and they're the group that were supporting Silva Takula. As you know, that issue arose in the media last week when it was discovered that Silva was buried without her family, her LGBT family in Galway, and her friends and family in the Great Western Hotel ever being notified. Thank you.
Thank you, Fiona. Welcome that additional documentation. Liam, I'd now like to invite you to address the committee, please.
Thank you, Chair. Deputy Senators, thank you very much for the invite here to discuss the system of direct provision in Ireland. I'm an Associate Professor in UCD School of Law, and human rights legal obligations and the system of direct provision has been a topic of my published research for quite some time. I provided the committee with a full submission and just wish to highlight some key recommendations which I invite the committee to consider. These include recommendations on better respecting and protecting the right to work for international protection applicants, reducing the length of time that applicants can access the labour market in, as well as ensuring that all international protection applicants who may be due to legacy issues are not being provided with the right to work. I invite the committee to recommend and recognise that the direct provision system in and of itself is a gross violation on the rights of the child and indeed all persons who may be subjected to the system of direct provision. I echo many of the recommendations, many of the many recommendations based on the detailed expertise of the Children's Rights Alliance and NASC, and would further call for an increase in the direct provision allowance, now called daily expenses allowance, and in particular, as a first step, to ensure that all children within direct provision receive the payment of child benefit. This can be achieved through an amendment to the Social Welfare Consolidation Act of 2005. I also make a number of recommendations on aged-out separated children. Aged-out separated children are those children who enter Ireland under 18 without a parent or guardian, and once they reach 18 are moved into direct provision. The direct provision system, as an institutionalised system, is absolutely and totally not appropriate for aged-out separated children. As the committee has heard over the previous weeks and again today, the system of direct provision is one that sets human rights at naught, that destabilises and impacts negatively on the rights of the child, the rights of families, the rights of individuals subject to this system. Established as a system that was intended to last no more than 6 months, we now have a system, as Fiona Finn mentioned, of institutionalised living, whereby international protection applicants will be subjected to this system for many years. The role of law and the role of state administration to date, as regards the needs of persons within the international protection system, is one that rejects international protection applicants as being holders of human rights. The state's approach to international protection applicants has sought to justify years of institutionalised living, years of an inability to do something as simple as to decide what should I eat, when will I eat, years of having to live in hostile-style accommodation, with little or no say over who you must interact with. Years of children never seeing their parents or guardians prepare a meal, always under the watchful eye of accommodation managers. What value is the phrase human rights, where the right to decide such intimate and basic aspects of one's life is withdrawn for many years without end? Time which does not have an end date. Convicted of no crime, international protection applicants are segregated from Irish society and condemned to live a half-life. That so many other countries in Europe, in the European Union, treat persons seeking international protection considerably worse than Ireland, is no justification for Ireland refusing to respect, protect, vindicate and fulfil the full array of human rights which all individuals, including international protection applicants, have under the state's freely accepted international human rights obligations. Based on my analysis of law, policy and the administration of the system of direct provision, I conclude that the system of direct provision is not fit for purpose. The system of direct provision must be abolished. Alternatives to the system must respect, protect, vindicate and fulfil the human rights legal entitlements, civil, political, economic, social, cultural, that persons within the international protection system have while their international claims for protection are being assessed. Failures in state administration for timely determination on whether an individual meets the definition of being in need protection is no defence to the significant rights violations that international protection applicants have been subjected to for almost 20 years. Replacing direct provision, as has already been stated, may not happen overnight. There will be cost implications. Protecting human rights are not cost-free. However, from nearly 20 years of testimony on the lived experience of international protection applicants, human rights-based research, much of it conducted, it has to be said, by NASC, the Children's Rights Alliance, the Irish Refugee Council, one thing is very clear. Direct provision was, and still is, A gross breach of the most fundamental human rights we should all have, the right to dignity and respect. Thank you.
Very much, Liam. Thank you for your address. Thank all of the contributors. And I now open it up to members. I have two indications, Senator Francis Black and Deputy Donegal Leary. Deputy Jim O'Caoláin, and we'll start with that. So, Senator Francis, you're first, please.
Thank you so much, Caoimhghín. And firstly, let me say thank you so much for your presentations today and for the detailed submissions that you sent in advance. You know, the committee is covering a lot of ground, you know, over the last few weeks and over the next few weeks. So I just want to focus on a few specific questions, if that's okay. And I also just want to, agree with you that this, I have no doubt, this is a gross violation of the rights of children and families, and it truly is shocking. And what we've heard over the last few weeks, for me, has been really upsetting and shocking and frustrating. So there's a couple of points that I just wanted to kind of, I hope that's okay, highlight. The first one is on housing. And on the issue of housing, there's two key messages that I'm hearing. The firstly, responsibility for protection shouldn't fall to the Department of Justice, as their expertise isn't housing and social care. It's not in housing and social care. And secondly, you say we need to move away from institutionalisation. And Fiona, you described this as an out-of-sight, out-of-mind approach where asylum seekers are isolated and kept at a distance. And you suggest that after a very short initial period of reception, it would be better to have a form of owned or clustered accommodation embedded in communities. So I was wondering, could you expand a little bit on how this might work in practice, and especially how we could do it while ensuring support and services were available? That's the first. Yeah. I'm going to just Caoimhghín, I have a few things I'd like to highlight, so I'm going to ask another one, and then if it's okay, I can come back in. Is that all right?
Okay.
And then the other issue I wanted to highlight is standards and preventing abuse. It's a key point every week that has been made for common standards and oversight to prevent abuse. You all suggest HICRA as a body who could do this, and I've no doubt this is absolutely crucial. It's a key recommendation that we as a committee have to make. At a minimum, we need common standards for reception and real oversight with teeth to investigate and prevent abuse. At the moment, if two asylum seekers arrive in Ireland, one may be sent to a centre with cooking facilities, better transport and more space. The other, through no fault of their own, may end up in a centre with none of these things. And it just doesn't seem right that pure chance can decide this. So from your presentation, it seems that on a human rights basis, we should be ensuring that every applicant is treated equally as a baseline, and that their specific needs or challenges would be taken into account. And I would love if you could comment a little bit more on that. And then if it's okay with you, Caoimhghín, I'll come back in then after. Yeah, thank you.
Fiona, would you like to take that up first?
Yeah,
please?
I mean, looking at the alternatives, I agree that, first of all, looking at the Department of Justice having sole care and responsibility for protection applicants. It hasn't worked for the last 20 years. I think we've learnt that lesson now. So I think we do need to kind of do something a bit more radical. And I think I would agree with our colleagues in the Refugee Council that housing, whilst it's not a housing issue per se, but housing forms the key, really, or one of the key components of how we care for international protection applicants. And the way the current tendering process is structured, and from our engagement with, say, for example, approved housing bodies who have huge expertise in housing and social care, are saying that the current tendering process is not it doesn't suit them, because it's very much focused on kind of institutional, very large congregated settings, and they have a very clear ethos and a very clear mission, and it doesn't match with them. So I think we need to start doing a bit of work. The department needs to start looking and engaging directly with approved housing bodies, and starting to move the model away from these large institutional settings, the smallest of which, if you look at the tenders, is about 50. And again, 50 for kind of any approved housing bodies is far too large. It doesn't fit with their ethos. So we're looking at maybe small, kind of what we call kind of pepper-potted accommodations and settings, moving away from the larger settings. Then there's also looking at the Department of Justice should look to build for-purpose reception centres as well, units, and they would have to be, I mean, the bottom line for any new reception centre would have to be own door accommodation, self-contained units where families can live together in a unit. Yeah. I know a lot of people have argued that asylum seekers should be allowed to live in the community and, you know, have access to full housing and social welfare. That is another option. It has been tried in other jurisdictions. But the Scotland model has, I suppose, it's kind of surfaced a lot of issues and challenges with that, because a lot of vulnerable protection applicants have been left isolated in communities. So what we're trying to do is to look at the system that best suits protection applicants, rather than creating an institutional setting and then putting protection applicants into that and then expecting them to somehow fit into that system. But I do think we need to change our thinking on it, and we do need to start looking at different models. Our current model of institutional housing of protection applicants is clearly, it's not working. And I think, you know, tinkering with it and changing with it, it's not going to change the fundamental underlying faults with the system.
Yeah.
Thank you.
Thank you.
Senator, just to say to the panel that if any of you wanted to add any particular point where the member may not have asked you directly, but if you want to add something, please just indicate, and you're very, very welcome. Tanya, please.
I just wanted to add something to that. I completely concur with what Fiona has just proposed there. In terms of thinking about the wraparound services and the approach that might work, a good example would be the area-based childhood initiatives, which are run by the Department of Children and Youth Affairs in conjunction with TUSLA. And if you look at how those programmes were set up, an area was asked to pitch for an initiative or a programme, and lots of different providers came together. They formed a kind of steering committee, developed different approaches and run them in the community. So there's lots of different examples of how you can provide services to vulnerable people, lots of success stories of how that works. So we could borrow from that, actually, as a solution. And just to follow on, I suppose, from what Fiona was suggesting in terms of the Scottish model, and as I understand it, they put people within housing communities, and it is a potential solution that you could have an approved housing provider potentially leasing properties around the country, because we know there's some parts of the country where there's lower density, but obviously if you're going to do that, you have to make sure there's a wraparound services for those people as well. So there are lots of solutions actually out there, and it's about thinking big. It's about not thinking about doing the same again and reproducing the same. It's actually looking at what's the best way to have good, sustainable housing accommodation solutions for a vulnerable group of people for, and hopefully, a short period of time.
Thank you. Yeah, no, Liam, I was wondering.
So, no problem at all. Thanks for your question, Senator Black. Asylum applicants being treated differently, why is that the case? The honest answer is I don't know. I should know. Why? Because within normal structures of decision making, there should be documents that suggest, right, if people are going to be sent to one centre or the other, what criteria will we be utilising in order to make that decision? Does such a document, does such an internal policy exist within the Reception Integration Agency? I've never seen it, and I'm inclined to believe it doesn't exist. So that those decisions are taken, I'd imagine, due to, and as the other two contributors had mentioned, there's real significant pressures on the system of direct provision right now, which means that it might be crisis management mode, and it will be, we will move people either into direct provision if we have space, or indeed just to hotels if we do not have space. What's the rationalised basis for making that decision when you have several applicants before you? I don't know, but I should know, and we all should know as to what is the basis for decisions on dispersal being made. And just one point, if I may, as well, Caoimhghín, and it's just on, I suppose, standards within institutionalised settings. I would maybe exercise a note of caution here. When you begin saying, oh, well, we can have standards that can watch over settings that in and of themselves grossly violate human rights. It gives some form of comfort that the system in and of itself is fine. And while they may be very appropriate right now, when we aren't moving away from direct provision, let's just maybe proceed with a note of caution on the standardisation of everything. We don't have standardisation in our lives. So it's very important, and it is due to the state's failure to properly realise the rights of those in the international protection system, why we suddenly need these standards. But human beings need to be, where possible and where appropriate, live free to make decisions such as where I can cook, what I can cook, who I should sleep with, where I can sleep with. When we start saying standards, oh, maybe the room should be this metre squared, that gets into deciding really intimate aspects of people's lives, which I personally am really uncomfortable with. Thank you.
Okay.
Thank you so much.
Okay, Senator Black.
Thank you. Yeah, so another issue I wanted to kind of touch on, and maybe you could help us, is the right to work. And, you know, that has come up frequently, and it's an issue I'm extremely passionate about. I mean, we heard a story a couple of weeks ago about a man with a family saying, all I want to do is work. Just let me come home to my children, you know, and tell them that I went to work today and I don't even want payment. You know, that's like he just wanted to get up in the morning and go and do a day's work and come home and tell his children, this is what I did today, for his pride, for his own. Anyway, so we know that many asylum seekers said they found this very limited so far and difficult to access. So I have two questions. And again, Liam, you mentioned that applicants can work after 9 months. If no first instance decision has been received, as I understand it, 9 months is the minimum standard allowed under the EU Receptions Directive, but there's nothing stopping us setting it at, say, 6 months. Would I be right in saying that? So I was wondering, could you say a little bit more about that? And then secondly, if we say that the right to work is fundamental to human dignity and well-being, then why is it only available to those without a first instance decision? Surely if an appeals process is permitted and can take time, then those rightly awaiting an appeal have just as much of a need to work, provide for their families and use their skills. And then also I wanted to ask about the likelihood of legal action against the state. And again, Liam, this is for yourself. Your longer submission focuses on the various fundamental rights that are being denied by the system, such as privacy, autonomy and decision making, and the rights of children. And Section D covers socio-economic rights, which are guaranteed by human rights instruments. We've already seen a limited right to work extended as a result of legal challenge. In your view, could we see further legal challenges on human rights grounds? Similarly, we have a long history in this country of warehousing people, looking back in horror, apologising and then setting up costly redress schemes. So do you think this process should be repeated here?
Okay, Senator Liam, would you like to take lead of this one? Yeah.
Okay, thanks for your question, Senator Black. You're absolutely correct in identifying that Ireland only adopted the minimum standard, the minimum obligation of 9 months under international human rights law, in particular the United Nations Committee on the Elimination of Racial Discrimination, which Ireland may be before in November, December of this year. For other European Union countries, that UN Human Rights Treaty body has stated that at a minimum 6 months may be a more appropriate time, although as I emphasise in my full submission, maybe we can go beyond even that minimum human rights standard. So the EU Reception Directive does not comply with minimum human rights standards as regards the delay in accessing work where a first instance decision is not made. I'd also absolutely concur with your analysis that work is so fundamental to human dignity and well-being that maybe we should consider to what degree maybe those who have had a negative first instance decision would be permitted to work while they await the outcome of their appeal before the International Protection Appeals Tribunal. Now, there's in my longer submission, and I won't go into the precise details, but there has been an interpretation given to the 2018 reception regulations that firstly said, from memory in October 2018, that once you were waiting 9 months, regardless of whether it was, if you were waiting before the 2018 regulations came into force, and if you got a negative decision, well, you'd been waiting the 9-month period, so you're awaiting appeal now, so you should be permitted to work. The decision maker for the International Protection Appeals Tribunal felt that she had got that decision wrong in a later decision, so she resigned and said she didn't want to continue with her incorrect interpretation of law that she might have applied, so that you have a significant number of people who are still awaiting their appeal, who had awaited a first instance decision for well over 9 months, but cannot work. So I absolutely echo that. On the likelihood of legal action in the state, there has been attempted legal action previously in a case known as CA and TA. One of the core arguments in that case was that direct provision system was a violation of the right to private and family life under the Constitution and under the European Convention on Human Rights Act of 2003. That case failed, not because Mr. Justice Colm McKeoch had said, the reason it failed was Mr. Justice Colm McKeoch said that the applicants, Ms. CA and her child TA, had not provided the requisite legal standard of proof to show that in that particular instance their right to private and family life had been violated, although the Honourable Judge, Mr. Justice McKeoch, did state that he feels direct provision is an exceptionally alien environment for any sort of child to be reared or indeed to just go about one's normal life.
Thank you.
Fiona, please.
Just with regards to the right to work, we made a number of kind of recommendations on this in our longer submission as well. And absolutely we'd agree with Liam on introducing maybe a grandfather clause, which would allow people who had been waiting for 9 months prior to the introduction of the regulations to work. This wouldn't be a particularly difficult thing to do. It could even be done as a matter of an administrative scheme as well. We also just noted there's a number of just kind of practical difficulties. For the people who have the right to work itself is actually relatively broad comparative to other jurisdictions. So for those who have it, it's good. But there are a number of small limitations that could really make a difference. So through our work in the legal clinics, we get quite a few phone calls from employers because they don't understand what this piece of paper is that people have. It's quite different to what other non-EEA nationals would have. So they ring us for information. But I think there needs to be maybe a kind of an information campaign, or by the Department of Enterprise perhaps, to actually educate employers as to what the rights to work for asylum seekers. Secondly, the permission is for 6 months. Most employers don't want to invest in an employee for 6 months. You're not going to give someone training to do a relatively high-skilled job for a 6-month period, whereas if it was a 12-month permission, that would definitely encourage employers more. And we've tried to explain that, look, after 6 months it is renewable, but I think the fact that it is 6 months, it feels very limited. And of course then there are the very practical barriers about access to driving licences and bank accounts, which I know have cropped up in other hearings as well. But it does show the need for kind of multi-agency and multi-departmental involvement in issues relating to international protection applicants, because it is within the aegis of the Department of Transport to resolve that particular issue around driving licences. And this wasn't an issue years ago. It is something that's kind of happened in the last maybe two-ish years. And for a lot of people, they're living in relatively rural or very small urban settings, and there's just no way for them to get to work. So they're living in settings where there's often low employment, so they're very much limited in what they can access. So that does really need to be resolved for people to actually be able to enjoy the rights that they do have.
Okay.
Okay.
Can I
Senator.
just a couple more? Just
A couple
comments,
more.
if that's all right. And I just want to come to yourself. I'll put them together. Yeah, I'll clump them all together.
Okay.
Just Tanya, I was just wondering, could you say, a little bit more about, children being institutionalised and the impact on their mental health, their long-term impact on their mental health, and just to maybe expand a little bit, if that's okay. And then I just want to come back again to Silva Tucula. I really do want to highlight this case because it was absolutely horrifying. Devastating to hear what happened. I mean, she died in direct provision. You said it there, buried with no friends or loved ones present. I mean, it's just heartbreaking, and it sums up the cruelty and the indignity of the system, and the fact that she was buried alone. So I really do think this highlights a fundamental problem, which is that the system of direct provision is patchwork. There are cracks all over the place, and real human beings are being let slip, through them. And in this case, you have 4 or 5 different bodies involved: the Gardaí, the department, the RIA, the coroner's office, the centre management. But no one really took responsibility, and it's not good enough to say it was a breakdown in communication. So I was wondering, do you think the gaps in the system like this are common? And I leave it at that.
Thank you very much, Senator. To whom will I address it first? Tanya, would you like to?
Yeah, and then I might pass on to my colleague then. I
Julie,
suppose
that's great. Yeah.
One of the big things we have seen for children living in the direct provision system is institutionalisation and the effects of it, and the effects on their parents. And children live through this. One of the best official insights is the HICWA report of 2015, which looked into the social work services that were being provided to direct provision. And what they found in that report was children who were hungry, children who didn't have enough clothes, children who didn't have access to toys or play facilities, so very basic things that is part of a childhood that you need for development. A lot of welfare issues, and actually really the big issue that was coming through that was impacting on children was the mental health of the parents. So parents are living through years of a system where you're not cooking for yourself, where you're reliant on everyone else for everyday decisions, and not knowing what's going to happen in the future. And when I went around to those centres, I asked people about the child protection issues, and the parents would say, I am the person that my child is most at risk from. I am breaking down. I can't take this anymore. And you will see through the Child Care Law Reporting Project, actually, there's a very significant number of cases. They are overrepresented in the numbers of children taken into care. And there have been children taken from parents because their mental health has broken down in the direct provision and because of the direct provision system as well. But the kind of other effects that you see around institutionalisation is around how children are being treated by centre owners and managers. So you'll find in one centre actually children treated very well, children seem to have very good rapport with the people running the system, and you go to another centre and the children are completely institutionalised and tell you lots of different accounts of things. So one of them was, a child told me about, they were in the kitchen, in the catering facility, and they saw the staff making smoothies in the kitchen, and the kids got really excited thinking it was for them. They'd never had a smoothie before, and the staff saw the kids and slammed the door. And what the kids realised, they weren't for them, it was actually for the staff. That's what was actually taking place. And you hear lots of accounts like that because the staff themselves are institutionalised and they are subjecting the children to ill treatment and maladministration. Essentially, that's kind of what's happening. The other thing that you would have seen a lot was poverty as well. So children talked to us about hunger was a huge thing. So particularly in one centre in Athlone, the food was really appalling. The children were being served. They're in school till, let's say, 3 or 4 o'clock. They come home. The parents have been given a bag of kind of deep-fried food. It would be spring rolls, white rice, etc. That was inedible for the children by the time they came home from school. And that wouldn't have been the case with all centres either. So that meant the children didn't eat. And because they're only on £9.60 a week, the parents didn't have any kind of supplementary income to buy other food for the children as well. And you also had obesity coming up as well, because the kind of food that was provided to children was so poor. Children would also talk to us about how ashamed they were to tell everyone they were living in direct provision, and so they would avoid play dates, or where they were being asked to go on a birthday party, they just say they weren't available because they didn't have the money to buy a birthday present to go along. And parents that talk about having to make these really difficult choices. So, you know, I'd love to send my kids to the local hurling club. I know it's only €2 or €3, but the problem is, you know, I need to buy a bottle of Calpol, and how do I afford one over the other? So obviously the increase in direct provision payment has been very important for those really basic things, so children can participate in everyday life. But the reality is, if you're going to mind children and give parents the best opportunity to be a parent, they have to be cooking for their own families. They have to have their own front door. I mean, the kind of things we were hearing was a parent wasn't allowed to leave a 14-year-old in the main reception room. Children weren't being allowed left on their own, and that's not good from a child development point of view. Children need to grow. They need to be able to play sometimes on their own. They need to be away from their parents. They need to be able to go, and that particularly happens as they get older. They want to become more independent. So again, that goes back to the need for this own door accommodation where children can have a normal childhood and near communities, not an isolated community, so they can mix in with other Irish children and any other children and just have a normal childhood. I did want to pass on to the issue for the children in unaccompanied minors that I mentioned earlier. When I was on the working group, we met a lot of children. Aged out minors is a technical term. I met one young guy who was about 19, and he had arrived in Ireland at the age of 12, and he had a Dublin accent, and I met him in Galway. So I was, because I'm a Dublin, another Dub, and he was really angry, and he was in this particular hostel where it's all men, and they eat together in a room where the security guard sits in the glass box, so very prison-like conditions. And what he was really angry about was he had a family in Dublin, and he had a life. And he said, no one told me an application for protection had not been submitted for me. And I found out about it, and then I get sent down here. And I've been ripped out of the community and the family that I had in Dublin. And why did this happen? Why did no one tell me in Tusa that this was going to happen to me? And there's a very particular legal issue of why that's happening. I want to pass on to my colleague Julia Hearn, who's been coming across this through our legal advice service.
Yeah, so through our legal advice service, we've known this was an issue through our members. They've been presenting us the information anecdotally of situations they hear of young people, particularly young people who come into the system aged 16, where they're coming into the system as an unaccompanied minor, and there's no application for put forward for them in the protection process. So we set up our legal information service there back last year, and it's an issue that's been cropping up. And what I'm hearing is that young people have no knowledge that an application has to be made for them. They've no knowledge of what implications this has. And this has key implications not only for what happens to them when they turn 18, but actually for their family reunification rights. So if an application is made when they're a young person, it is far easier for them to start applying for family reunification at that point as well. And what we were hearing is that it's not necessarily anything, a kind of a devious motive behind it or anything like that. People are making a decision looking at it from the point of view of, will this further harm the child, but not looking at long term what this is going to do to the young person. So while they might take a decision, well, at 16 I don't want them to have to relive the experience, at 18 they're going to be put into direct provision, and you have to look at, well, actually, is the system fit for purpose if that is what people are thinking, that it's going to further harm the child. So they need to look at child-friendly justice measures, different things that can be put in place to make sure that if you are coming into the country at 16, people don't have a kind of a fear of putting you through an application process that is in your best interest to get a status because they think the system might harm you. The system should be adapted so that fear isn't there. But it's something that we're going to continue to document as part of our work, and I suppose track the trends and what's happening on the issue. But it's an issue that I suppose that really needs to be highlighted because it really does harm children who have no one else with them in the country.
Thank you. Julie, Tanya, you wanted to add a
One
point?
more point on this, the mental health solution. What the research is telling us and other countries, the best practice models are, because some children in the refugee population will be very resilient actually and won't need any support, and some children will be very damaged by what they've gone through. So it seems in school provision is best. So a psychologist that's actually present within the school system where the child can go and have sessions and get that kind of support. So we need to be thinking about what the school is doing in terms of a refugee child and what extra supports that they're setting up. Generally, when they set up a special kind of refugee mental health service, they always get defunded in recession times, and then the expertise gets lost within the system. So we really need to equip NEPs and the existing services to take on the needs of refugee children. But it's something where there's a huge gap, because we know in one part of the country the service is good, one part of the country the service is bad, and that's something that needs to be looked at.
Did any of the rest of you want to add? Fiona, please.
Yeah, no, I'd like to add just on the issue Senator Blackie rose about patchwork and about Silva Takula. I think it's kind of two issues. I think what happened to Silva Takula was appalling, and I think that is emblematic of the institutionalised nature of direct provision, and it is that whole kind of process of othering. So I think Silva was no longer really, it's kind of the dehumanising impact that direct provision has. So when Takula sadly died, it just became a function. Do you know what I mean? So there were certain procedures that had to be followed. So we're going to do and follow those procedures without ever thinking that she may have a family, and family is much broader than having kind of immediate next of kin. And I think that is a direct that is a direct result of the institutionalisation and how we treat protection applicants. Around the kind of patchwork element then, I think I agree with you. I think there are an awful lot of services available in direct provision, and there are an awful lot of agencies involved in the provision of reception. And I think what is required is almost like an oversight, like a refugee advisory body. It was recommended in McMahon, and it was also in the original Refugee Act 1996. And the idea is that there will be some level of oversight and there will be some level of coordination. Because if you go from kind of centre to centre to centre, you see in some areas, say Tusla are extremely active in a particular area and the services provided for children are very good. You go somewhere else and those services don't exist. So there's no coordination. So I think the idea of establishing an advisory board to oversee all aspects and elements of the protection process, including the determination process and the services that are provided, is absolutely required. So then we have a more of a coordinated response, not an ad hoc kind of patchwork response that we have throughout the country.
If I may, just with regard to Silva, just from the statement that we received from Amach, they have a statement included within that again from a fellow resident, and I think it really sums up the situation. She said that she was easily fooled to believe that the system will show love to Silva while it failed to show that love to her while she was alive. It really sums up what happened. There was no love or compassion for Silva. She was forced to live in an all-male hostel, which, you know, I find it really difficult to get over the horror of that and how difficult that must have been for her on a daily basis. If the vulnerability assessment had been in place at the time that Silva had come into the system, one would hope that that would never have happened. And that's one of the reasons why we do need to have a vulnerability assessment in place, so that no one should have to go through that again. I think that's really important. Another piece from this statement from Amach also highlights the fact that residents have also kind of highlighted to them their fear that something could happen to them if they died, or if something happened to them, would they also be buried alone? And there is that fear. People really need to be reassured now that lessons have been learnt and that this will not be repeated again, and that, you know, Silva will leave a legacy where there's been positive change.
Thank you, Fiona. Thank you. And thank you, Senator Black. If I can, just before bringing Deputy O'Leary in, just to remind members that at the conclusion of today's hearing and in preparation for our report, I'd like to invite you for a group picture with the members. So I'm saying it now in case they all disappear on me, and that wouldn't do. So thank you for noting that. Deputy O'Leary.
Let me go in ahead if that's okay, Chairman. I have to do a radio interview at 11 o'clock. Apologies. But listen, thank you very much for coming in and for your very helpful submissions. Obviously, so that you're aware of the process that we're engaged in, We're obviously having extensive hearings. We're going on a visit to a direct provision centre on Friday, and then we produce a report. And obviously what we want to do is put into the report recommendations that we believe will improve the system as much as possible. I suppose we have to be practical about it as well. Like, we want to put forward recommendations that we think can be adopted and implemented. And I think we've heard a lot of them today from you in terms of what you were suggesting, Tanya, about the HICWA unannounced visits and vulnerability assessments we've heard before, and also issues just in terms of entitling people in direct provision to have access to driving licences and bank accounts. These are fundamental, simple issues that we should be able to deal with and the state should implement. But can I just ask you, Julie and Tanya, in respect to the issue you raised just earlier about 16-year-olds who come in here and an asylum application isn't lodged on their behalf, like, who do we think should be responsible for that, for advising them, or how should they become aware of the fact that they have to put in an application?
Please.
Well, at the moment, it is the social worker who has the responsibility to make a decision whether or not to lodge an application for them. What I'm hearing is social care workers, they're the people who care for them in where they're living on a day-to-day basis. They're coming to me saying, listen, what's happening here? What are the rights of the young person? Who should be the person in place? I might leave that to Tanya. But what is critical in this is actually that child-friendly information is provided to children and young people. This would be in a language they can understand, would be both written and oral, and would be in a way in which they would know what their rights and entitlements are, even beyond making an application for protection, but actually what their rights are in everyday life as well, and that that's there and accessible.
I mean, unless the child has an appointed guardian, which is possible, so some of these children do get into foster care. That's obviously the best outcomes, and unless the foster care is appointed a guardian, it's going to be the social worker whose responsibility for lodging the application. And the issue is they have decided not to do that, and they have decided not to do that for, we would hear, other reasons. Let's say it might be a welfare, as Judy says, it might be because they're concerned about the nature of the protection process. They don't want to put the child through that. But I suppose what they're not balancing is the protection rights of the child, and actually it's the child's best interest to get the application actually in as early as possible, and it's up to the state to adapt its own system to make sure it's as child friendly as possible. And children can undergo these kinds of situations. Children are very resilient, and often refugee children are more resilient than others. And we have to look at them in that way as well. I suppose it came up through the McMahon work, and a recommendation was made that the social worker should get legal advice before just making this decision. And there is a provision in the recent Protection Act around that. It says that the social worker may get legal advice, but we just don't know what's happening. And we know from our experience on the ground and from the helpline, it would seem they're still not going and lodging the protection applicant. So it's something that needs to be opened up, because we do think those decisions are not being made in the best interest of children. Do they need legislation? I don't know, but they certainly need guidance in relation to making that decision.
And the problem that arises is that a person who comes in at 16, when they become 18, they can find themselves transferred to a direct provision centre.
Yeah, that's right. That's right. That's right. And one way to address that, I suppose, is by designating them aftercare, because one of the problems with getting to enjoy aftercare at the moment, if you are 16 when you enter into the childcare system, it's very hard to get aftercare. So there should be an exception for those young people, because you don't have a family. You're arriving here with no other adults who are there for you to back you up, like any other child that's had a family here in Ireland. So that's the solution for them. They should be kept in aftercare, and by providing that, getting their application done, getting their family unification application done, then their family can arrive and look after them and be there for them. That's the solution for them. Okay,
and do you think social workers need to be better informed about the importance of these applications being lodged, or should we go down the McMahon route of providing them with legal advice in respect of the application?
I certainly think there needs to be, the child needs to have its own lawyer, basically, in these cases, and the lawyer should be advising on behalf of the child, and that actually can address the gap, I think, with the social worker. I think that's one way around it, is good legal.
Fiona had a point to come in on the back of your earlier question. Fiona, please.
Just to add to Tanya's point, when the issue arose within the working group, a lot of the working with the NGOs in the group wanted to obligate the HSE to seek legal advice, but that got watered down in the International Protection Act. So seeking legal advice just forms one part of many agencies that they may consult. I think there's two things. I think it should be an obligation, and I think, again, if we're looking at early legal advice and front-loading legal advice, that forms part of it. But also very, very, very critically is that if a child turns 18 and then goes through the asylum process and gets a permission at or after the age of 18, he loses all rights to family reunification under the new Act. So there is no possibility that he can apply for his parents or
whereas if he did it at 16 or 17,
and that's why I think it's really critical, is if he was granted a protection status at the age of 16, 17, or even up to the day before his 18th birthday, he will still be entitled to family reunification. And I think that's critical. So then you have a whole group of children who are orphaned in reality in the state.
Yeah, thanks very much. Just to have one other thing, I think, Fiona, you were mentioning that it might be better to move this from justice to maybe housing.
Yeah.
Would you have any concerns? Like, it's not as though we do housing particularly well in this country. Would you be concerned if we were transferring it from a justice issue where there is an absolute obligation on the state to provide shelter and support for people who come seeking asylum? Like, if they were just fully integrated into the system without that protection, you could nearly call it, they'd be left to the housing lists,
That protection would still exist?
Yeah.
Because that protection wouldn't be removed if it's moved from the Department of Justice. That protection is there under international law, so that wouldn't move. I suppose what we would suggest is maybe it is kind of attached to, or like a separate entity that is added on to maybe the Housing Department, and then the funding that is coming, the funding for provision of accommodation, is mainstreamed into the housing budget, but it's ring-fenced. So it can't be drawn from, or it can't be used for any other form of housing. So I think it's only by taking and looking at it from a kind of a housing or a social housing issue that we'll start to begin to move from the current model that we have. And I think, you know, I suppose the ethos of justice is very much, you know, it is a kind of like a control type of ethos, and I think you don't get that if you move it to another body. Okay,
and just finally, Liam, thanks very much for your research in the area. Like, has any research been done on the impact of the direct provision system on children's access to entertainment in primary education? Is that an issue you're concerned about?
There has been a study done, I believe it's by Dr. Jackie Horgan and others in University College Cork. That study focused more on how children, and more so their parents, they come from a very institutionalised setting of direct provision, and when they then go in to deal with primary schools, sometimes the treatment they receive is not all that pleasant and is not all that different from the control experience with direct provision centres. I believe I have it cited in a footnote, the precise study. Could I possibly just just to back up some of the points made by Tanya, Julie and Fiona on aftercare, there had been, firstly, legally speaking, nothing prevents TUSLA from offering aftercare to age-separated children. To my knowledge, that discretionary power of TUSLA has never once been exercised. Dr. Morni Rahla of University College Dublin, in a number of studies going back to 2013, has pointed out that what we are doing is that we are providing, and we have to recognise Ireland has, for those under 18, those who are separated children, we have one of the probably best systems, certainly in Europe, if not the world. Yet what happens once a person, you know, and it's all about building resilience, building independence, building capacity. And as Dr. Rahla has noted, what then do we do once they turn 18? You go and live in an institution. Your meals will be provided. Here's a few bob for yourself for a week. So the early part of their entry into Ireland is one where there is some form of wraparound care, and then we say, right now, you're 18. Off you go into a hostel where we are taking every single decision possible away from you.
Okay, thanks very much.
Thank
Thanks,
you.
Chairman, and thanks, Donnacha, for letting me in there.
Deputy O'Callaghan. And now, Deputy Donnacha O'Leary, please.
Thanks very much. Caoimhghín Ó Caoláin as Fenshaw agus Tun Vian Don Sport Trishva and a Loper. Thank you all for being before us. I suppose first of all to say that I very much agree with the criticisms you've made. I believe that direct provision, and we've had this debate over the last few weeks, including with Justice McMahon, and while there may be points to incremental improvements, I believe that fundamentally direct provision is a bad system and is a system that has failed people's human rights and continues to fail people's human rights. And I also believe that not only has it lost the confidence of those who have to suffer the system, who are in the system, I believe it's lost the confidence of the Irish public as well. And even aside from the enormous, the multiple human rights issues that exist in relation to it, it's been extremely bad value for money as well. Like I've instanced this before, but it's cost the taxpayer 1.25 billion since 2001 to house, if you want to call it that, in the direct provision system. A parent with 2 children costs 40,000 a year through the direct provision system. Much better accommodation, much more, I suppose, private, much more accommodation with much greater dignity could be provided at much less of a cost than that. So, from every perspective, I think that the direct provision system is in urgent need of replacement. And I suppose what's been outlined is very much in accordance with my own views in terms of an integration of the housing approach. I raised that with the Minister last December, advocating an approach such as that. And I suppose, like even in response to Deputy O'Callaghan's point in terms of justice and housing, it's like any of these things, there has to be an intersection, I think. Like, you know, there obviously, you can't expect that the Department of Housing will be responsible for making a determination on somebody's application for international protection, but in so much as they are to be accommodated and to be provided with accommodation where that is needed immediately, I think there does need to be a housing approach to that, and I think if certain approved housing bodies can have a role in that. I believe that the private for-profit model that has underpinned this has been a significant problem. I suppose NASC and the Children's Rights Alliance have dwelt a fair bit on this, but Dr. Thornton, like, are you in agreement with that kind of approach that involves either approved housing bodies or some form of Department of Housing led or public housing led initiative? Is that roughly where you think? And I know there's many other issues relating to the direct provision, but just in terms of bed and board accommodation.
One, not a housing specialist.
Yeah. Okay.
Don't have any expertise in housing policy.
Fair enough.
However, how do we engage with, I suppose, other people within the state who are not within the international protection system who need support? Well, welfare needs will be catered for by the Department of Employment Affairs and Social Protection. Housing needs may be catered for either through, not that there's much, but local authority housing, rent allowance or now HAP payment. I do have issues with not mainstreaming supports provided to asylum applicants. We have significant levels of government departments who are engaged with various issues, from the Department of Health, Department of Social Protection, Department of Housing, obviously the Department of Justice as regards determination of claims. Is there a need for absolutely and wholly separated systems, while acknowledging for a small number of applicants that there may be much more need for kind of more engagement and more holistic supports provided? So, just from my very limited lens that I can offer my advice to the Committee on Law, how in law do we deal with those who may not have enough income? We have payment from social protection. How do we deal with those who may be suffering or not suffering, who have homelessness imposed upon them, or who have to access housing payment supports? Well, we have housing, social protection. healthcare, Department of Health, child needs, Department of Children, etc. So my approach is we have systems in place. Let's utilise those systems regardless of the legal status of international protection applicants, while acknowledging there will be a small number who will need a more interventionist approach.
This was just from my own point of view, and just to put this on the record, like, I mean, I agree with a lot of what you said. And I suppose it follows on from a previous point, the point of applying for the mainstream system and having, I suppose, specific accommodation for people who are applying for international protection. I don't think are mutually exclusive. Like the way the system is at the minute, unfortunately for the entire population, housing, you know, if you're a single applicant, you'd be 9 to 11, 12 years on a local authority housing list, particularly in the cities. So what makes sense to me is that you have your accommodation provided immediately. It's of a standard. It is own door accommodation, but that you have the entitlement to apply for local authority housing, and if you can find it, which is very difficult at the minute, that you can apply for HAP just the same, but that you have to have that minimum standard to be able to work from. Because if you force people to wait for their application to be processed and their status to be granted, that could be 3, 4, 5 years, maybe more, and then another 9, 10, 11, 12 years on top of that before you actually get accommodated. I suppose just on the, there was a fair bit of discussion there on the unaccompanied minors, and just a brief question, maybe including some of the submissions, but is there an available figure for the amount of unaccompanied minors in this system at the minute?
Is it the numbers of unaccompanied minors, is it? It's actually quite small, to be honest, in contrast to other countries. It's quite difficult to get here. And one point to kind of make was, I suppose, there has been an issue with unaccompanied minors in Europe. A lot of have travelled to Europe, and Ireland has by far not taken the lion's share of them, to be honest. There was a situation, as you know, with Calais, a number of young people there. Ireland did actually travel, Department of Children, Youth Affairs and TUSA did travel there and offered, you know, full refugee protection, full services, accommodation, etc. And actually only a small number of young people opted to come to Ireland, which is really interesting. But it actually reflects what we know is that people want to go to the country where they have other family members. They don't want to go to a country where they don't have anyone. And we're always told in terms of the direct provision system that if we make it too good, they'll all want to come. It'll be a pull factor, when actually the research doesn't tell us that. The research tells us again and again and again the reason why people choose the country they go to is the trafficker has taken them there and they had no idea where they were going, or that they have family members there and that's where they want to go. So essentially we have a small number of unaccompanied minors in the country, to be honest. The system of reception is quite good for them, but the real issue is coming down to their legal protection needs, that they aren't being effectively dealt with, and they should be prioritised, dealt with very quickly so they can do their family unification application, and then they should be kept in aftercare if it so happens that they do turn 18.
Okay. And I suppose connected to that, I think probably would be or opting into the recast directive. One of the requirements that is the vulnerability statement. I presume that would relate to unaccompanied minors as well. Can you maybe, any of the witnesses, give a statement on where they believe the vulnerability statement is at in terms of progress, in terms of that being implemented and applied?
I mean, our understanding is at the moment that there are discussions between Department of Justice and Department of Health. And I suppose that's what comes from the kind of very siloed approach we have at the moment to dealing with reception and international protection. I'm not sure where they're at, so it's a case of does the responsibility for vulnerability assessment lie squarely within the Department of Justice, or does it lie for the Department of Health? So I'd say it is somewhere in between. Obviously, it's a vulnerability assessment. It goes beyond a health screening. So our sense of it would be that it is a health issue. That's what it is. But obviously, additional funding has to be provided to the HSE to deliver on the vulnerability assessment. And then the other key part of the vulnerability assessment is it's not just a once-off assessment. So it's not just when you arrive in Balseskin that you have an initial assessment. So they look to see if you have reception, if you have special reception needs. Firstly, those special reception needs need to be provided. So they may assess you and say, actually, you're not suitable for to reside in direct provision centre, we need to provide alternative accommodation for you. And also, the vulnerability is ongoing. The vulnerability assessment is ongoing. So there has to be systems in place whereby, trauma may emerge 6 months, 8 months after people arrive in the country. That needs to be. There needs to be enough services there to be able to detect and respond to that. And the standards provides a very, very, very good pathway for the delivery of the vulnerability assessment on an ongoing basis throughout the centres. So, like, the foundation blocks are there. The standards have been agreed, or the vulnerability assessment. Standards have been agreed. The vulnerability assessment is a legal obligation. It's over a year now, and it still hasn't happened. So, I mean, for us, I think it is a critical piece. So, I can't answer you. I don't know where it's at, but I know it's somewhere batted between Justice and the HSE.
Okay.
Thank you.
Okay, thank you.
Deputy, please.
Yeah, okay, thank you very much. I suppose just on some of the other points, and I think some of them have been raised and probably answered already, but just to make a brief statement on themselves, entirely agree on the point in relation to right to work. I think it is the people who, are perhaps in most need of it, and a huge amount of the people who are in the system longest don't stand to benefit from it, and that is wrong. Just in relation to, and I think it's been touched upon as well, the locations, some of direct provision centres, and I'm certainly not of the view that all those locations should necessarily be located in Dublin, but some of the locations in terms of their appointments in Dublin are just absolutely impossible to manage by public transport. I think there's one that was mooted to be located in Moville or something, which would require passing through the 6 counties, which just isn't actually, I think, allowed.
Getting arrested,
yeah.
Because Northern time being is a separate jurisdiction.
Yeah. Yeah.
And it's illegal for a protection applicant to move into a country without permission either of the Department of Justice here or the Home Office in the United Kingdom.
Yeah, so, like, I mean, I think an awful lot of those locations, I think, left an awful lot to be desired, and I think that needs to be looked at as well. I suppose I would agree to a large extent with the note of caution, and I would take it as a note of caution rather than opposition from Liam in relation to the minimum standards. Like, minimum standards has to be, I think, an interim measure ahead of replacing entirely the direct provision system. That's my own personal view. I think they certainly have a role. I suppose what does occur to me is, maybe you have a view of this, I would imagine when these come into place, a huge amount of direct provision centres will be very far short of these minimum standards, I would expect. And that being the case, I suppose, what happens then? Is there a possibility that direct provision centres are closed, that people are put into emergency accommodation? I suppose that's just a thought that does occur to me. Like, I know the amount of people in emergency accommodation, I think, is huge already. I think it's something like 600 according to a PQ I have, which is, a system in and of itself, and quite frightening in and of itself, I think. So maybe just to put that question to the witnesses.
There's no doubt that the standards does require a higher level of provision. There's no doubt that that needs to happen. The solution to this should be this: number one, the state should start developing a national housing policy for people seeking protection. And one of the key things that's in their gift is they can get building. There's actually great examples of accommodation provision, and not necessarily within the refugee space, but in other areas of provision, like, say, with people with disabilities. They could be out building accommodation now, solid, sustainable accommodation, that, if it's not in use for people seeking protection, could be handed over to other people that have a housing need in a particular area. And there's lots of parts of the country where that kind of housing and accommodation could happen. I suppose the second piece is, as Fiona has said, is bringing in the not-for-profit housing providers, because all the research shows when they provide housing, it's pretty good actually, and the outcomes are quite good for the people that they're working with. If they made money more available to those housing approved providers, they're more likely to pitch actually for this type of accommodation. And there's lots of them, and even for-profit providers that work within the disability space, if they were given the resources and the support, they could actually produce own-door accommodation and use the pepper pot model and have care people on staff. This is not insurmountable, it's actually possible. And then the other piece that we suggested as well, so your three-part, you have your building programme, you tender out to your not-for-profits for pepper pot type accommodation, and the third piece is to have providers lease housing and accommodation around the country where it's available, and that is possible. We know that there's lots of vacant properties around the country, and make sure that people are provided with the right services and support. They're all the solutions, they're all there. There's plenty of housing providers and practitioners out there that are happy here to advise the Reception Integration Agency. They just need to make it happen.
Thank you. Fiona, please.
Deputy Leader, your question on the standards, yes, I agree. It's not going to change direct provision. It's kind of a short to medium term improvement, but it will, when they're in, vastly improve the conditions in the centres, because one of the critical issues is conditions differ from centre to centre to centre. And I think when the committee goes and visits centres, I think it's very important that you visit a number of centres so you get a true sense of the variety of the conditions that are out there. But also with regard to the standards, current providers have a 2-year lead-in period. So say the standards come into place in 2020, then providers have 2 years to bring their accommodation up to the requisite standards that are within their accommodation. So it won't be a case of, oh, you're not meeting the standards, so you can no longer be a provider. So that kind of that 2-year lead-in period was brought in to enable current providers and new providers to start bringing their accommodation up to scratch and within the standards required in the national standards.
Yes, please, Julie.
If I could just come in on the emergency accommodation issue, that's a real worry for us at the moment, because there's big questions around child protection and welfare. If you're in a current direct provision system, if you're in the system as we know it, as it was, there's an obligation on them to comply with Children's First, which we raised in our submission. But we don't know what is happening in these emergency centres. Do they have a designated liaison person? Are there child protection systems in place? Do they have their statement? And that is a real concern for us, that there are children living in potentially very dangerous situations. And another issue related to that is the need for a child protection and welfare strategy. If there was a child protection welfare strategy in place, it could address what happens when there is an emergency accommodation centre, what happens in terms of child protection. And then related to that is the vacancy which Tanya mentioned. So there is currently a vacancy within RIA and it's in the Child and Family Services, and that person would actually be able to have oversight over what is happening in terms of child protection in these situations, these emergency centres. So it is key that that position is filled to try look and have oversight over the gaps that are existing in emergency services at the moment.
Thank you, Julie. Okay, back to you, Deputy.
And I agree 100%. And the scale of what's happening there now is actually becoming quite large. And I think it is an emerging issue and potentially an emerging scandal, I would say. Just two more questions, I suppose, and it relates partially to that, partially to direct provision generally. And the point has been raised about inspection and the ability to have oversight of what's happening in centres. Is there a role for when the state approves the optional protocol for the Convention on Torture, will that improve the oversight of, I suppose, not just direct provision, but all sorts of other locations? And I suppose the final one is, is there a part of this, like when we're looking at structure and accommodation, is there a part of this that we need to address culture within some of the institutions? Because, I think that's a big part of what happened with Silva Takula. I was on the radio about it in my instance, the contrast with the case of Sean Parker, who was in London, and the local authority there they went that extra mile to try and find somebody in Galway that would be able to give him a burial with dignity and fitting and be properly remembered. But nobody went that extra mile. People can say, oh well, I wasn't notified, nobody told me. Nobody went that extra mile, nobody went that extra inch really in that instance. And that to me speaks to a culture, and it's not just real. I think it extends to Inish as well, and it's excessively adversarial at times. I remember, it's one of the most incredible sentences I ever read in my life, I think, that I was reading a previous report to this committee and some of the witnesses that came in and some of the determinations that had come down from Inish. But one of them was a refusal of family reunification which questioned the degree of destruction in Syria, saying it was noted that central Damascus had been relatively unscathed by the war in Syria. I remember reading that and thinking, that's just incredible. And like, is there a cultural element within Inish and RIA? And there's very many good people in those organisations as well who are doing their best to assist people who are fleeing conflict and who are seeking a better life here. But is there an element of which there is an excessively adversarial attitude to applicants for international protection, and do we need to tackle that culture, or am I completely off the mark there?
Final question from Deputy Leary. Who would like to take it, Liam?
I will take the culture of justice, of RIA, of 20 years of freedom of information documents at my disposal. I think you're very generous describing it just as adversarial. I'd go stronger, but I'm not going to right now. It's much, much worse than that, I fear. And there's just a culture of disbelief, which has been documented amongst several reports. I recall documents from a Freedom of Information request in 2008, where a chap had a child with a woman. The child was an Irish child because the mother was Irish. This person was in a direct provision centre, asked could he be moved to a DP centre closer to his girlfriend and their child. And it was referred in the body of the email by the official as another brain teaser on direct provision view. Their response: there's no obligation upon him to remain in direct provision. It's none of our business if he wants to live near the mother and child, and if he he may have access to his own funds. That's just one example. There's more recent examples when the Department of Employment Affairs and Social Protection, they had started planning for the increases in direct provision allowance in and about July of last year. They quite wisely didn't inform Justice until about the 25th of September of 2018. And when an official in Justice was asked to offer a comment or views, the official in Justice just began saying, they're all working anyway. Just two of, unfortunately, so many examples that I have and will, due to the 20th anniversary of the system of direct provision, I'll be making available towards the end of this year.
Thank you. Anybody? Yes, Fiona.
Yeah, kind of builds on Liam's point around kind of the cultural aspect of it. I think that partially the issue is because the Department of Justice controls all the aspects of someone in international protection's life, for better or for worse. So their remit is to uphold the security of the state and border control. So that's the mindset that they're looking at things through, rather than maybe a human care or more of a compassionate approach. In terms of like moving the accommodation to the housing providers, there's many reasons why that's so important. But when we see people coming through our clinics and talking to us, they're aware that their accommodation is provided by Justice. It's overlooked by the same body that's looking at their asylum application. And no matter how many pieces of paper reassure them that the two things are separate, and that if they make a complaint about one, it won't impact on the other, they're not reassured. So having Justice in charge of all of that is hugely problematic, because it's so many areas of different control. With regards to, you're talking about kind of this disbelief and the quote about Damascus, I have come across several visa letters where I put in applications for people and that was the response. And I think in at least one of those cases, the person wasn't living in central Damascus; it was in the suburbs. But yes, that is something that we come across, and cases like the ones that Liam's talking about people in direct provision who want to move to be closer to family, they're routinely refused. And again, that's because you're looking at it from an immigration control point of view. So moving it away from Justice to another provider would definitely be very helpful, I think, in shifting that culture.
Yes, Fiona, thank you. And Tanya.
I suppose, as you say, there's a lot of good people working within the system, and that would be my experience. But the kind of examples, I suppose, that Liam is describing is a system where you haven't been held accountable for your treatment of people. And you get that when you're talking about this very exceptional circumstance in Irish political life where one particular organisation did not have any scrutiny by any public body. And this is the kind of stuff that actually happens ultimately, and cultures set into an organisation. And on top of that, institutionalisation, the people within that system become institutionalisation and embedded and committed to it. That's the other bit that we don't to think about, the learning from the Ryan report and other institutional abuse reports, is that people working within the system really buy into it and try to reproduce it and hold on to it. So obviously change is important within this space. The other thing that we would have come across as well when we were on the working group was this, and it was a constant nearly battle, was care, the notion of care. We don't do care, we just do accommodation. And you wouldn't get that if you worked in other areas of life or other government departments, because there is this understanding it's a vulnerable population and we have to do care as well. And I suppose that's the change, I think, with the national standards, is this acceptance, understanding actually care is part of what we do now. And that's why we're really keen to get them implemented as soon as possible, because whoever provides the system will have to have a care component, will have to have social care workers on site who can actually deal with people's needs. I think going forward, I think actually making sure you have HICWA established is going to be really key, because you can see where HICWA goes in and does unannounced inspections, it does change practice. It absolutely does. And the other thing about the HICWA example is it's not expensive. So we were trying to cost up how much would it cost. We went into HICWA to find out. And when they had about 4,000 in the system, they said, oh yeah, that'll be 4 inspectors and 2 administrators. So we were like, my God, this is much cheaper than we thought it was going to be. So all you would need is really just a change to the Health Act, give HICWA this as a particular area, and they've already done accommodation for vulnerable people. They could take this on. They've already done cluster type accommodation, independent living situations as well. They have that expertise. It's a very simple thing to do. And if we give them a grandfather period, if we give the providers a grandfather period, there should be no reason why it can't be implemented.
Thank you, Tanya, and thank you, Deputy O'Leary. Our final contributor is Senator Niall Ó Donnghaile, please.
Carly, I have a very succinct question, I hope, to round off, because I'm conscious it's been a busy engagement for you. It's just to hone in the context of our report, specifically on Fiona's earlier point about the Refugee Advisory Board. I'm just keen to maybe try and tease out some thoughts on that. Certainly what we should be focusing in on, and if there is specific reference made to it, how we should be referring to that in the report. You mentioned the legislation earlier, Fiona, allowing for the board, and what form does it propose that it takes, because that doesn't always translate into the best form.
I know.
So it's really just in terms of because for me the last thing you would want or need in the context of this issue is another layer of bureaucracy.
I agree.
So we would need to get obviously the right people around that table, and also determine terms of reference around its functions and its powers and its remit. So it's really just, I'm not across the detail of that. That was sort of news to me this morning. I just want to get a broad view on that, sure.
I think from memory, and I may be incorrect, but in the Refugee Act 1996, I think it set out who should be part of that board, and it was, in general, it was just to oversee the actual determination process and look at asylum policy. And I think that board, was it every 2 years they were to meet, and then they were to lay a report before the Oireachtas. So I think that was it was a really good model, because in a sense it was giving the decision makers, and there was accountability. And what we were kind of looking at is, and they were to meet 4 times a year, but we were looking at is maybe looking at that advisory board, and given the fact that there are a number of other agencies that are involved in the delivery of direct provision. So you have TUSLA, you have issues that are specifically arising around children, you have issues that are specifically arising around LGBTQ people, that may be looking at broadening that advisory board, and maybe looking something like the model of the working group, which actually, for all its faults and failings, worked very, very, very well. So you had a cross-governmental department. Now there could be a sense of maybe they visit, or they meet maybe 4 times a year, they meet quarterly, reports are provided from each particular department on progress they've been made, issues that are arising, and then I think that information either gets made public, and I think there's a very good case to be made that looking in particular at the protection process, the actual determination process, that the model that was set out in the 1996 Act be followed, that there is a biannual report that's laid before the Oireachtas, and I think that gives it a huge sense of a very strong degree of oversight.
Yeah.
I'm happy enough with that, Chair.
You're okay with that? Well, look, it only remains for me to thank you, but I thought it was interesting, the comment in relation to HICWA, Tanya, and the impact, the unannounced visits. Ours, unfortunately, are announced, but I'd hope, even in that context, that they have more than just the benefit of engagement. It will be interesting to see. We're visiting both Mosney and Monaghan to have a contrast between one and the other.
Yeah.
And I'm
It's
familiar,
quite striking, yeah.
very familiar with both, particularly the latter. So we have felt that it would be a very important part of the address of the issue, and particularly for members who wouldn't have attended it either before, and I've been to both myself. So there we are, and we'll also be in the land of emergency accommodation because there's quite a number of clusters, so-called, in that part of the country where I'm honoured to represent the people. Unfortunately, it's not something that we're most proud of. Again, it remains for me only to thank you all very much indeed. You're the last of the NGO sector coming before us. We're dealing with the officials in our final hearing next week. So I would like, on behalf of the Justice and Equality Committee, to thank Tanya and Julie, who have been with us before. Lovely to have you back, and thank you for your contribution here today. To the two Fionas, who have travelled from Cork, both, I think. Yes, you're both very welcome. I thought that Donnghaile would have started off. You know, he has a tendency to relate to home base first, but he didn't. He put Liam in that position today. So, our thanks to you, Liam, as well. You had the least journey, perhaps, to be with us here today. In any event, to wish you all the very best. We will invite you for a photograph now at the conclusion, but very, very importantly, I'd like to put you on notice that we will extend an invitation to you when in the autumn we are publishing our report. And we hope that out of our own deliberations over the remaining period, that it will be a report that you will find satisfaction with. Thank you very much indeed. So it remains for me only to say that the Joint Committee is adjourned until 9 a.m. on next Wednesday, the 19th of June. Gora míle maith.